So mmeongeza iko list. Morning everyone. Welcome to course number 4. Presiding Magistrate, Honorable Robin Undeki, Prosecutor Ms. Bange, Court Assistant Stephen Haroro. Kindly let us ensure that our mobile phones are on silent or vibrator mode, and when your name is called out, please do respond. Ukiitwa jina tafadhali unaitika, tunajua kwamba uko kotini.
Let's start with the judgments. Number 1, Gilbert Deya.
Gilbert.
Let me know what present.
Mhozi mbrief kwa Msintela kwa the state. Msintela pia kwa alongside Msintela.
There's no case number here.
Again, I'm not seeing any representation. Maybe the accused person can address the court.
Where is that?
I hope this will be here maybe.
So you are ready to take the judgment?
Yes, I'm ready.
All right, in this judgment, there are the preliminary issues that I want to comment on as part of the introduction. Number 1, the question of historicity of miracle babies has elicited many speculations. Many are the philosophical theories, as there are many speculative thoughts on the subject. We find as many different answers as there are systems of thoughts with diverse perceptions of ideological framework. This question in itself is the greatest enigma to many and heaviest cross for the intellect to bear. There are two, and while the first holds the view that the term miracle babies is an illusion, the other school of Christians are of divergent thoughts. We find that the performing miracles is one of the gifts of the Holy Spirit, as recorded in the book of 1 Corinthians chapter number 12 verse 28, which says, "And God had set some into charge, first the apostles, secondary prophets, thirdly teachers, after that miracles, and then gifts of healings, helps, governments, and diversities of tongues." May I sample a review of some of the provisions of the Bible which attest to the subject of miracle babies and which I find useful on the subject. Number 1, Genesis 21. For Sarah conceived and bare Abraham a son in his old age at the set time which God had spoken to him. 1 Samuel chapter number 1. There was a certain man whose name was Elkanah, who had 2 wives. The name of one was Hannah, and the name of the other Peninnah. And Peninnah had children, but Hannah had no children. Eli prayed for her, and a son was born, and she called him Samuel. Judges chapter 13, there was a man by the name Manoah, and his wife was barren. The angel of the Lord appeared unto the woman and said, She shall bear a son who shall deliver the children of Israel who have been taken in captivity by the Philistines 40 years. A son was born named Samson. Matthew chapter number 1, Mary, the mother of Jesus, bore Jesus at the behest of the Holy Spirit, and at the time she was espoused to Joseph. We read Acts 10, verse number 11. John was the miracle child through whom Abraham's seed was carried on spiritual. His birth prefigured the entry of the Gentiles in the Christian church. Now, these are but a few biblical provisions to demonstrate indeed miracles do exist, and that the miracle babies have been born at the request to God or caused to be born so moto. That's all I can mention on miracle babies, and so whether one proclaims to have the gift of miracles or not is another story altogether. But importantly, for my case here, the accused person is facing charges under section 174 1B of the Penal Code, chapter 63 laws of Kenya, as there are no known offenses relating to miracle babies recorded under the Penal Code. The other issue which I must mention before we proceed is the age of this case. This is in respect to timely dispensation of justice. The Constitution has invested so much in democracy in terms of the rights and the fundamental freedoms set out in Part 4 of the Constitution. For instance, Article 52E of the Constitution in Kenya 2010 recognizes the right of an accused person to a fair trial, which includes the right to have the trial begin and conclude without unreasonable delay. The Constitution and the former Constitution do not define the period that could constitute unreasonable delay. However, in other jurisdictions with similar provisions in their laws, the courts have, through judicial innovation, developed an interpretation that weighs various factors before setting a presumptive ceiling beyond which the delay could be considered unreasonable. For example, Section 11B of the Canadian Charter of Rights and Freedoms, it provides, I quote, any person charged with an offense has the right to be tried within reasonable time. This provision has been the subject of far-reaching judicial interpretation and innovation. The famous Canadian Supreme Court case R versus Maureen, 1992, Supreme Court at page number 771, the court declared as a guide that the threshold of reasonable time within which a criminal must be concluded is 8 to 10 months in the provincial courts and an additional 6 to 8 months in the superior courts. From the date the accused is arraigned before the court, that is a total of 14 to 18 months. The same Supreme Court in Canada, Jordan versus R, Supreme Court 27 of 2016, the aberrant trial in that case had delayed for 4 years between charges and the end of trial, and by a majority of 5 to 4, set a new framework under Section 11B aforesaid, holding that it could be a possible presumption of an unreasonable delay if the accused was to wait for his trial to be concluded for a period in excess of 18 months in cases tried in the magistrate courts or provincial courts for that matter, and 30 months for cases in the superior courts, thereby expanding the presumptive ceiling set in the Maureen case. The court also held in that case, where it is demonstrated that Section 11B has been infringed, the remedy is to stay proceedings and set the accused at liberty. In Kenya, through its performance management initiative, the judiciary has set frameworks for each level of the court within which criminal trials and appeals must be determined. For instance, in the magistrates courts, the trial must be determined within 360 days from the date the suspects are in court. Similarly, 360 days in the High Court, 180 days in the Court of Appeal from the date of